So Chapter 6 is all about the Second Amendment. This is usually a pretty popular topic, so we'll go ahead and just jump right in. The Second Amendment starts off with, in quotes, a well-regulated militia. So first question is, what's a militia? And this is an armed group of citizens who defend their community as emergencies arise. And so the central controversy over the Second Amendment has been whether that right to bear arms is for an individual person by person right, or whether that right is only if you're a part of a militia. In the time when this amendment was added, the militia was made up of free male citizens who were armed with muskets, bayonets, and rifles, usually of their own, sometimes provided. But today the militia is considered to be the National Guard in every state, and it is armed with government-supplied and owned weaponry. Additionally, the militia is in addition to our standing military. So modern-day militias, your book has a lot of information about what's going on with these, and even that some of these groups are considered to be domestic terrorist threats. So when we think about the Second Amendment, there's this controversy over it, and so some people feel that the government has been, the kind of premise for one side is that the government has become too powerful, and so individuals need to have the option to reclaim that power by owning and possessing a firearm. The other side is more concerned with the rate of gun violence that occurs, in particular mass shootings like Newtown, Tucson, Virginia Tech, Columbine, Aurora. So those are kind of the two camps. One side thinks the government's too powerful. The other side is very concerned about the amount of gun violence that occurs in our country on a year-to-year basis. And so there are two opposing legal interpretations of the Second Amendment. The first is, does the Second Amendment guarantee an individual's right to keep and bear arms, or does it guarantee that states' freedom from federal infringement on this right? In other words, that the federal government cannot tell states that they cannot have a militia or that they cannot regulate firearms within their states. So those are the kind of the two legal bases for the controversy. Each side kind of goes with one camp here. So the Second Amendment phrasing is one of the biggest parts of this debate. So the Second Amendment has two parts. One is called an operative clause. The operative clause is the part that identifies the action to be taken or prohibited. And the second part is called the prefatory clause, which announces a purpose but does not necessarily restrict the operative clause. So just go ahead and note, these are not legal terms, these are just grammar terms, like grammatical issues, but a lot of law kind of focuses on what the law means, and we interpret it based on how it's written. So that's why we're spending a couple minutes here on grammar, operative clauses versus prefatory clauses. So if we hop over here and look at the text of the Second Amendment, the Second Amendment text says that a well-regulated militia, so we'll go ahead and note that this is the prefatory clause, being necessary to the security of a free state, so prefatory clause. The operative clause starts right here. The right of the people to keep and bear arms shall not be infringed. And that's the complete text of the Second Amendment. So the operative clause is that the right of the people to keep and bear arms shall not be infringed. So if you read that prefatory clause, think that binds the operative clause. That's one legal argument. The other legal argument is that that prefatory clause is not binding, and that therefore this is an individual right. So that's kind of how the text of the Second Amendment is set up for this particular debate. Now, So the individual right proponents endorse that this is an individual right that is guaranteed to all citizens. And so this is a right that's guaranteed to the people, not to the states. Now we'll go ahead and note throughout the history of our country, this has not been the thought of what the Second Amendment means. For about 200 years, it has been interpreted to be a state right, a militia right. So this has been in the minority for most of the time until we get to 2008, I think. Now, states' rights see the Second Amendment as protecting and modifying Article 1, Section 8, which is the Commerce Clause, and gives Congress quite a bit of power. Most of Congress's power comes from this Commerce Clause. And so the purpose of the Second Amendment is to make sure that Congress cannot infringe on a state's ability to operate its own militia, and as part of operating a militia, have its militiamen and women be armed. So so again, this is kind of the primary purpose, is to protect the state militia. So let's look at some of the case law at this point. So in 1934, Congress passed the National Firearms Act, which was one of the first efforts to regulate firearms. And in that, in 1939, when that made it to the Supreme Court found that the Second Amendment is a state right, and that it only protects firearms in relation to a militia right. So that kind of was the law until we get to the Harr decision, which resulted in a shift in interpretation. So in every case except for until we get to that point, all state right, militia right. So when we get to Harr, 2008, the question was, is the Second Amendment violated by a provision of the Washington, D.C. Code that bans the possession of functional handguns in the home? And the Supreme Court said yes. The Second Amendment protects an individual's right to possess a handgun in one's home and use it for traditionally lawful purposes, regardless of any connection to the amendment or to the militia. And so this opinion was written by Justice Scalia. If you want to look it up, it's a really easy read. Justice Scalia is a fantastic writer. So, individual right. Now, DC is kind of governed by Congress, so federal law applies there. So this is the federal law. So this does not apply to the states. Remember, if we think back to the incorporation doctrine, rights had to be incorporated one by one. So this only applies for federal government. So in 2010, we have the Second Amendment incorporated to the states in McDonald v. Chicago. So the city of Chicago had banned all handgun possession by private individuals. Mr. McDonald sued and argued that this left him vulnerable to crime. And the Supreme Court held that the Second Amendment right is incorporated by the Due Process Clause of the 14th Amendment and therefore applies to the states. So this is really recent in Supreme Court world, in the legal world. It's only been a few years that this has been interpreted as an individual right, not a state right. So as with all your constitutional rights, the right to keep and bear arms is not unlimited by any stretch of the means, and so states retain the right to impose stricter regulations than those required by the federal government. States do that in a variety of ways. Some of them have concealed carry laws, some of them prohibit concealed carry, some states have open carry, some states have castle laws, some states have restrictions on the type of firearms that can be owned and possessed within their state limits. So states still have a lot of freedom. We're going to note that states can also restrict certain types of persons from purchasing a firearm, like convicted felons, people with mental illnesses. So states can do a lot within this still. They still have a lot of power to regulate firearms. We're going to note that the Supreme Court in 1995 struck down the gun-free Zones Act, which prohibited firearms in schools across the country. The Supreme Court found that that was a violation of the Congress's power. They exceeded their power because that is not related to commerce. Again, so we have different regulations based on types of firearms that are perfectly fine. Let's look at a little bit about federal regulations of the Second Amendment. So we have a few different acts, but the most recent act is the Brady Act in 1990. One of the more recent ones is the 1993 Brady Act, which provided a mandatory 5-day waiting period on all handguns. But that was phased out in 1998 with the permanent provision of an instant computerized criminal background check on all handgun purchasers except for those made at gun shows. But some states still do impose that a waiting period of some sort, even with the background check. So we have the Violent Crime Control and Law Enforcement Act of 1994, which banned manufacture of different types of semi-automatic weapons. It prohibited transfer in possession of handguns and ammunition by juveniles. It prohibited possession by those who have committed a domestic violence crime. Harsher penalties on the federal level for use of firearms in crimes, and it expired with a sunset clause. So this has not been renewed. All right, Law Enforcement Officer Safety Act allows off-duty and retired officers to carry concealed weapons throughout the country regardless of state and local firearms restrictions. So this was to kind of just establish equality between local law enforcement and their federal counterparts, and to allow current and retired law enforcement officers the means to defend themselves. There's been a lot of proposed legislation that hasn't really gone anywhere, looking at not allowing those who are on the terror watch list to purchase firearms. This has support from both sides, but it just hasn't been able to get passed. There's been proposed to close the Gun Show Loophole Act of 2009. Again, it just hasn't gone anywhere. And again, we're going to touch back in a little bit on gun control at this point because it's important. So why is this such an issue? Why do people care so much? Why are people so passionate about it? Whether or not you agree with him, like Beto Cruz was able to successfully launch a bid for the Democratic nomination kind of based almost entirely on a gun control platform. So there is just a lot of concern, and his campaign was instantly attacked by those who support guns and a more robust gun ownership abilities. So there's a lot going on here. One reason is that firearms account for about 70% of all homicides from 1993 to 2011. So most homicides are involve a gun. Guns are used in a lot of other crimes as well. And another reason for concern is that law enforcement officers can be killed by civilians with readily accessible gun ownership and gun availability. So there's just a lot going on here. Now, this just provides a little bit more about opposition to gun control, that this will kind of create a black market. It'll put guns where they don't belong. We have a right to defend ourselves, versus the other side, which is crime control, which advocates the ability to kind of regulate crime. So the last slide here in this chapter deals with, is compromise possible? And we'll go ahead and note, gun control by states is not constitutionally prohibited, so states could enforce pretty strict gun regulations. Legislation by the federal government is also not prohibited, so the federal government could take action here. As of right now, courts are continuing to defer primarily these issues to the discretion of states. I will note that the Supreme Court was set to hear a Second Amendment case this term, They may not make any significant ruling though, because New York repealed the law. New York passed a law um, which really restricted firearm ownership, and then they repealed it, so the issue is moot. There's no issue right now. So we'll see what happens here, but it's likely not to be anything big. Also, go ahead and note that Adam Liptick is a really respected Supreme Court reporter. All right, I hope that you are all well.